driving the Silverado. And he's told the officers that you and him agreed to meet up at a Shell gas station on 1960. He drove to the gas station parking lot, but then you drove away. Let's see. There's a person by the name of Donna that witnessed the accident and left her phone number. Okay. Officers did a investigation. They found out that the vehicle was registered to you, Anthony Tech. Okay. And so they decided to go ahead and contact the district attorney's office, and charges were filed against you back in May of 2023. There was a warrant issued for your arrest. That warrant just happened to be out there all of this time until it looks like you got detained last week, right? You went to jail? All right. When you went to jail, they found this warrant. You were released on a bond. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. So, Ms. Garcia, this is on page 17, Anthony Tech.
Yes, Your Honor.
All right, Mr. Tech, there's an individual that's accusing you of this offense, okay? Let's see here. Tilfus Perry is accusing you of this offense, and I have to believe you don't know who that is, right? So, Ms. Garcia, do you see the to-be warrant?
Yes, Your Honor.
Do you see the name on the very first paragraph? It says Tilfus Perry, the complainant. It's on the to-be warrant, the very first paragraph, and it says it happened on May 5th. And right next, the next sentence, it says vehicle driven by Tilfus Perry, hereafter called the complainant.
Your Honor, send it. Yes, Your Honor. I see.
So we have no contact.
Yes.
So you're not, the court's going to order that you do not have any contact with that individual that's accusing you of this offense. No contact means not call, text, email. Shouldn't be a problem because you don't know who it is, right?
Yeah.
Okay. Secondly, the court's going to order while you're in bond, you'll be prohibited from possessing any firearms or any weapons. These two conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, you're going to need an attorney to represent you on this case. Are you working right now, sir? What type of work do you do? Painter? How long have you been doing that?
5 years.
Do you work for yourself? Okay, because you have been working and had steady employment for at least 1 year, the court's going to require you to hire your own lawyer. We're going to reschedule your case to allow you time to hire an attorney. Now, if you do hire a lawyer, have that attorney contact this court before the next court date. You, sir, do not have to come back to court as long as you have an attorney representing you. However, if you don't have an attorney representing you next court date, you will have to return to court. All right. Do you have any questions on anything I mentioned to you? All right. Right behind you, the table. My preacher also go with her. Sounds conditions. Have a seat. We'll reset your case. Millie, page 17, Anthony Tech, THA.
No violations.
Morning.
Morning, sir.
You need approach?
Yes, sir.
Come on up. What you got this morning? How are
Here,
you?
Mr. Martinez.
Martinez. Let's see.
It's an arraignment docket, Judge.
Oh, okay. No worries. Give me 1 second. Is it Martinez Delgado?
Yes, sir.
Okay, I got it right here.
He's present.
Okay.
Judge, I need to get it.
Oh, interpreter?
Yeah, interpreter.
Okay, Millie.
Let me get that.
Okay, no worries. Okay, thanks. As soon as he gets here, we'll
I
approach.
forgot about that, Judge.
That's okay.
Yes.
All right, I have one more PC. Oh, Mr. Lagon, come on up.
Hey, Judge, just approaching real quick on Calzada Carvajal.
Let's see here.
Yes.
Oh, yeah, I got it right here. What's happening with that case? Racing on the highway?
Yeah, he was set for bond forfeiture.
Okay. Okay, good.
This is one where he was supposed to get 8 hours of community service done. He has not got that done, but I just talked to the state and they're willing to substitute the community service for $100 donation.
Oh, really? Okay.
So,
That's reasonable.
yeah, so I think, I was just gonna see if we could roll this to like Wednesday.
Are you sure? I can do it in the next week if you want. Are you gonna be around Wednesday or
Better.
are you gonna be around next week?
I'll be around next Wednesday.
Okay, so I'll tell you what, get with Millie, let her know, roll it to next Wednesday. Tell your client, pay it.
He'll get it done.
All right, and then, and if they can do it before next week, they can dismiss it off docket.
Yes.
Okay, you got it, Ms. Leno. Thank you. Welcome. You're welcome. I do have one more PC
Yes.
and it's going to be on. Okay, give me 1 second. Now I lost it. Okay, last name is Leha, first name is William. William Leha, coming up, sir. It's for PC. Okay, so you are William Leha?
Yes, sir.
Mr. Leha, you don't have a lawyer today, right?
No, I'm in a process of going.
All right, no worries. I just wanted to inform you, sir, that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we'll talk about an attorney. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/5/2025, officer conducted a traffic stop on defendant in a parking lot in Harris County, Texas. Witness advised that he observed someone asleep in the vehicle. Officer observed defendant asleep in driver's side seat with engine on. Officer observed mild odor of alcoholic beverage and glossy eyes. There was an open bottle of beer in the cup holder. HGN 6 out of 6. Walk and turn 1 out of 8. One leg stand 1 out of 4. Officer located cocaine on the defendant. DIC was read, breath was refused, and a blood warrant was signed. Defendant was previously convicted of DWI on May 19th, 2006 out of Court 2.
All right, Mr. Leha, the court is going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of driving while intoxicated. Now, I see that you were convicted of the offense of driving while intoxicated in 2006. So this makes it a driving while intoxicated as a second offender. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. It also means that if you had a valid Texas driver's license at the time of your arrest, DPS may suspend your license as a result of this arrest. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. So, Ms. Garcia,
Yes,
this is on page 10, Leha.
Yes, sir.
All right, Mr. Leha, the court's going to order that while you're on bond, you will be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. And you're also going to be ordered to undergo random urine test. Okay, I do see that you were also charged with the offense of possession of a controlled substance. And I see that the bond conditions on that one requires you to do urine tests. So, Ms. Garcia, UAs, but he's going to pay the UAs because the court upstairs, so it'll be defendant paid. All right, Mr. Leha, these conditions of bond are going to remain until this case is over with. I am going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, you are going to need an attorney to represent you on this case. I see that your other case was rescheduled to 6/25 for you to get a lawyer. So we're going to reschedule your case for the same day, June 25th. Now, Mr. Leha, if you do get a lawyer, just have that attorney contact this court before the next court date. You, sir, do not have to come back to court. You let your attorney take care of your case. However, if you do not have an attorney by the next court date, you will have to return to court. All right, sir, do you have any questions on anything that I mentioned to you?
No.
All right, right behind you, the tables, my preacher also go with her, sounds conditions, have a seat, we'll reset your case. Millie, page 10, Leha, THA. All right, come on up, Ms. Capillo, come on up. We got our interpreter here.
If you are not somebody.
Yes, sir. You're Argenis Martinez Delgado. Hi, Mr. You're here with your attorney. I just wanted to inform you, sir, of what you are being charged with. You are being charged with the offense of assault of a family member. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. I see that this was an offense that was alleged to have occurred on June 28th of 2023. That's almost 2 years ago. There's an individual by the name of Gamboa Francis that's accusing you of this offense. I see that there was an investigation that was being done by the Harris County Precinct 5 Constable's Office. I see that they were, sent over to a residence in Katy. They met with Gamboa Francis, and Gamboa Francis told the officers that you were her husband and that she's accusing you of assaulting her. Okay. So the officers went ahead and did an investigation, and they contacted the district attorney's office, and charges were filed against you. Now, those charges happen to be out there all of this time until it looks like you posted a bond in Fort Bend County. Was he arrested on Fort Bend? Did he get detained in Fort Bend and they found this warrant?
Yes, sir.
Okay.
Got pulled over for speeding ticket.
Okay, they found the warrant? Yeah, okay. All right, sir. So I do see that you posted a bond out of Fort Bend County and were released on bond. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. Now, Ms. Anthony, do you see this case, Martinez Delgado?
Yes, Judge.
Do you know if anyone from the state has had any contact with the complaining witness?
Yes, Judge, they have.
Okay. Is she requesting any conditions?
Let me check, Judge. Yes, it looks like residency restriction and no contact
Now, did they contact the complaining witness recently?
this morning, Judge.
Oh, this morning, okay. Were you aware of that?
I was, yes.
Okay, and do you know, I'm assuming, I see that in the to be warrant, they were husband and wife. Are they still together?
No, sir. They were actually meeting up that day to sign divorce papers.
Oh, I see.
So they had been separated. They don't have any children.
Okay,
The only reason he has to communicate with her is to finalize the divorce, which is my understanding still has not been done.
all right. So she requesting no contact? Miss-
Yes, Judge. But if they have to, state would be amenable to no threatening.
2 years, almost, since this happened. So I had to believe there's been some type of contact since then. Okay, I'll order no threatening. So, Ms. Garcia,
Yes, sir.
it's on page 11, Martinez Delgado.
Yes, sir.
So, Mr. Delgado, the court's going to order while you're on bond, you're not to threaten, harass, or assault Gamboa Francis. You may speak to her, you may contact her, email, text, whatever. Just don't threaten her, harass her, or assault her. You will be prohibited from going over to her residence, wherever she may live. Don't go to any residence, okay? And you will also be ordered, sir, not to possess any firearms or any weapons. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, we are going to reschedule your case to allow your attorney time to gather all the evidence that he needs. On your next court date, sir, you do not have to come to court. You, your attorney will let you know if and when it's necessary for you to return to court. All right, sir. Do you have any questions on anything that I mentioned to you? Okay. Okay. You have any questions?
Yes, sir.
All right, sir. Right behind you, the table, my pre-trial officer, go with her. Sounds conditions, have a seat. We're going to reschedule your case. And just get a court date from my coordinator.
Yes, sir. Thank you, Judge.
Thank you. You're welcome.
Yeah, it was run in 2020.
Millie, on page 2, Barrera Ernesto, court appoint.
Yeah, yeah.
Yes, ma'am. Good morning. Hey, you're welcome. Yes, ma'am. How are you?
Good, how are you?
I'm good, thanks.
I have a Spanish arraignment on Ms. Ventura Davila.
Ventura Davila. Nope, got it right here. All right, let's call her Francia Ventura Davila. Now, I haven't heard PC on this. Would you like the court to hear it?
Yes.
Okay. And Ms. Anthony, this is on Ventura Davila.
Yes.
CFSGI. On page, yeah, it's on page 19.
Okay.
Page 19, if you need the cause number. You are Francia Ventura Davila. You're here with your attorney. I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you are being charged with. We're going to talk about any conditions of bond that the court may impose, and then we're going to reschedule your case. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/5/2025, officer is dispatched to a failure to stop and give information in Harris County, Texas. Complainant told the officer that someone had hit his vehicle while parked. Complainant did not see who, but got video footage from a neighbor. Video shows the vehicle and license plate of defendant's vehicle. Officers went to address listed and spoke to defendant. Defendant admitted to being involved in the accident and stated she was distracted. She told officers she got scared and left the scene. Damage was $2,000.
Any response to procedure? Okay. All right, Ms. Davila, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of failure to stop and give information. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning is the court's going to order some conditions regarding your bond. Ms. Garcia,
Yes,
this on page 19, Ventura Davila.
Yes, sir.
All right, Ms. Ventura Davila, there is a person by the name of Eddie Gonzalez that's accusing you of this offense. I have to believe you do not know who that is. Okay, so the court is going to order that you do not have any contact with Eddie Gonzalez. Do not call, text, email, no contact whatsoever. Secondly, the court's going to order that you are prohibited from possessing any firearms or any weapons. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. We are going to reschedule your case to allow time for your attorney to gather all the evidence that she needs. On your next court date, you do not have to come to court. You let your attorney take care of your case. She will let you know if and when it's necessary for you to return to court. All right. Do you have any questions on anything that I mentioned to you? Any questions? All right. Right behind you is my pretrial officer. Go with her. Sounds conditions. Have a seat. We'll reset your case and just get a date. You're welcome. Yes, ma'am. Thank you. Thank you, too. Yes, sir. Good morning.
Morning.
What you got this morning?
I call him Estes at Riverview.
What's the last name?
Last name Brown.
Brown. Let's see here.
Yeah.
In custody?
Yes.
All right. Let me see here. Oh, Kesha Brown. Let me see. DWI.
Things are kind of back to where we don't get a personal bond.
I don't understand. She's only got $100 bond, and it looks like,
This is eligible.
yeah, no, it's kind of funny.
And it's the usual bond paperwork.
I wonder, let me look at something. Looks like she got arrested yesterday.
Yeah.
I wonder if she's in processing.
She got here.
Miss Anthony,
Yes,
do you
Judge.
see this case,
Yes.
Kesha Brown?
Yes, Judge.
Do you see that if she has anything else pending county besides Harris?
Yes, I'm looking right now. It looks like she was on a DUI probation, but she should have been off of that in 2022. That's the only criminal history I'm seeing. Yes.
So you see a DWI case?
Yes, I see there was a DUI out of, I believe this is Georgia, that she was on a probation for.
State of Georgia, right?
Yes, yes, Your Honor, out of, in 2021, it was a 12-month probation, so it looks like that should be over by now.
Okay,
But that's the only thing I see.
all right. Well, if she does have that probation, this makes it a DWI second. And if that's the case, I'm going to issue bond conditions. I will release her. I want to give her a PR bond. Let me check something. Nancy, real quick. On page 23, Brown, she's in custody. Do you see anywhere on there where she might be released on a GOB? She's got $100 bond, but that's
It just says she's eligible, Judge.
really, that's all?
That's all. I don't know if she's actually been
It
getting.
looks like she got booked in yesterday, right? Yeah, I see 3 a.m., 5:11. So I bet you that she's eligible. Maybe the paperwork hadn't gone through, but not, she's physically here, right? Let me just do a PR bond. Ms. Garcia,
Yes, Your Honor.
on page 23, Brown, I'm going to go ahead and do a personal bond on her. She's in custody, but I'm going to raise the bond to 2,000, although it'll still be a PR bond. And Millie, page 23, Kesha Brown, I'm granting a PR bond on her. I just need to get a future date for discovery. July 20. Is that a good day for you? Okay, to July 23rd. So let me do that on a bond paperwork. All right, so July 23rd. But I am going to issue bond conditions. So looks like since she does have a prior DWI, I'm going to have to order an interlock. Do you have any idea if she has plans of driving a motor vehicle? Not prohibiting her from driving, But if she's gonna drive, which is fine, as long as she has a valid Texas driver's license.
So I went on that, but there was a refusal, so I assumed the ALR suspension would be there.
Yeah, but the ALR is not gonna take effect for another 45 days. But I just need to know if she plans on driving, because she just got arrested.
Yeah.
And there's a 15-day period that you can request for an ALR hearing. Not that you're gonna do it, because you're just appointed on this case. And I just need to know if she's gonna be driving. If not, I'm gonna order a portable and no driving.
Yeah, so I believe she will be driving, just kind of see how we handle that, address it later if we need to.
Okay, so then we'll order portable, no driving. She will be driving?
Yeah.
Okay, all right, so, then Ms. Garcia, let's order an interlock,
Yes, Your Honor.
waive the monitoring fees and agency pay,
Yes, sir.
and let's do random urine test too and waive those fees.
Yes, Your Honor.
And no weapons, no alcohol, controlled substance. So just let her know, no alcohol, no controlled substances without a prescription, no alcohol, interlock, we'll pay for the interlock, and then a random UAs, and we're gonna also pay for those.
Yeah.
So she's gonna have to come out here in a couple of minutes. Ms. Garcia, how is she, when she is released, she has to go to 49?
Yes, be up to her, Your Honor, once she gets released.
Okay.
To go over to
Okay, just let her know that once she's released from custody, she has to go to 49 Senior Center. Now, it's in the morning. If we do this, she might be released today, but I don't know how late.
Yeah.
I think pretrial is only there till 4 next door. So she might have to come back tomorrow. But just let her know to come pretrial, get her bond conditions, and then we'll reset her case for 7/23, and she's good to go. Okay?
Sounds good.
All right.
So I do have one more.
Yes, sir.
Last name Harvey.
Harley,
Harvey.
in custody also?
Yes, Judge.
Let me see, Harvey, got it right here.
Basically, it's kind of weird. I think she backed up, made bond like yesterday.
Oh.
She was bond made. They told me she be being released.
It's probably in processing then. Let me look at it.
Still, we need to do.
Let me look at it. All right, Nancy, page 27, Harvey.
Yes.
I do see bond made on 2 cases.
Yes.
Oh.
It's the other autopsy case, the one that you just made on.
Which one? The theft or the trespass? Because I see a trespass and but I see bonds on both.
Yeah.
Yeah, I see the PR bond on the trespass. Oh, God, I wish they wouldn't do this. Are you gonna represent on both?
I've been appointed both.
Yeah, let me look at the theft. I don't see bonds on the theft, Nancy, but I do see that,
It's in the system, Judge.
It is supposed to-
It's not in DCF.
so it is being processed. Okay, so he's gonna be released on bond. But I need to issue bond conditions now that he's here. Is he physically here?
Yes.
Okay, let's do this. Let me look at the theft real quick. Let me, come on. And trespass. All right, he's got bond conditions on the trespass. But I need to issue bond conditions on the theft. I haven't heard PC on it. Let me hear PC. Miss Anthony,
Yes, Judge.
this is on Harvey Duntae, Duntae. It's a theft.
Yes, Judge.
Let me hear PC on that theft case.
Yes, Judge. On 5/9/2025, officer was dispatched to a robbery in progress call at CVS in Harris County, Texas. Officer met with complainant, who was a store manager of the CVS. Complainant stated defendant was outside of the location causing a disturbance, threatening customers and digging through the trash. Complainant stated that he told defendant he did not mind him going through the trash, but not to make a mess. Approximately 20 minutes later, complainant observed defendant enter the CVS, and which he knew he shouldn't be on the premises because complainant told him earlier in the day to not come back because he took merchandise earlier by concealing them on his person and passing past all points of sale and walking out of the store. And the total was $44.84.
All right, so I'm gonna do bond conditions on Mr. Harvey also, so Ms. Garcia. This on page 27, Harvey, no contact or going over to the CVS. Do you have a particular location?
Yes, I have a location, Judge.
So do you mind giving that to Ms. Garcia? Just to, okay, and no weapons.
Yes, Your Honor.
So he's here too, right? We're gonna bring him out too also so he can sign those bond conditions and just tell him, don't go over that CVS and no weapons. Now, his other case that you're appointed, that's it for till 16, but let's off docket that. And I want to set both cases together. So just let Millie know to put those two cases together and we'll set them off probably sometime in June or July. Okay? And then we'll bring him out in a minute to sign those things. Okay, you got it. Thank you. Yes, you're welcome. Morning, how are you?
How are you today, Judge?
I'm good. How are you doing?
I'm good, Judge.
Oh, that's good.
Provost, he's in custody. Judge, I don't know if, I was trying to see if probable cause had been found.
See, I'm looking at the trespass to see why he's in custody on trespass.
Judge, he's in custody because the bond is set at 2,500, and I wanted to address,
You know why?
He's in the deferred, but they haven't filed a motion to revoke.
It's coming. I can assure you, it's coming.
well, on this one, Judge, the underlying case was a burglary at U of H. He goes there at 2:32. He was under the impression that he could not go back to that building, but he could go to the library and read books. So at 2:32, they saw him at the library and they filed a criminal trespass charge against him.
Unless he received notice not to come at all.
Well, Judge, when I looked at the probation conditions, it does not say anything about he is not, it says no threatening or harassing.
Yeah, but that's the probation. I'm talking about this case. So let's do this.
And I don't see where he received any notice.
Well, let's see. Miss Anthony,
Yes, Judge.
Provost, Provost, Eric.
Yes.
Let me hear the PC on this one.
Yes, Judge. On 5/9/2025, officer responded to the U of H Anderson Library in Harris County, Texas, after receiving information from a U of H security officer working at the library. While conducting a patrol check of the area, security officer recognized the defendant by sight from a previous burglary of a building report. Officer met with the defendant and was provided his name and date of birth. Officer provided the information to UHPD Police Dispatch and confirmed the defendant had one previous criminal trespass that was issued by Officer Ritchie, reference case number 23-1626. Defendant was again found on U of H property without legitimate business or authorization.
So he was asked not to come back.
And there's just the part that I'm not clear on. He was arrested for I keep saying B&B, but the burglary. And I don't see where he was provided any notice. I think what he was he was arrested. He was charged with burglary. And then I don't see where he was giving a criminal trespass. When I looked at and I thought maybe it was a part of his probation, but I don't see anything in there other than no threatening or harassing communication with the alleged complaining witness. He was at the library. He wasn't at the building. And I get it. If he was given a criminal trespass for the entire university, I understand that.
Yeah.
But he was under the impression that he couldn't go back to that particular building. He was at the library at 2:32 p.m. reading a book.
Well, but if
And I get it, Judge. If there is a criminal trespass, I just don't see it.
well, I don't see it in the probation conditions. You're correct. I don't see anything prohibiting him on his probation conditions.
Right, Judge.
But if the UHPD told him not to come back,
And that's the part I don't have, Judge. And I was gonna ask you, could you consider giving him a PR bond on that, Judge? Because that is a missing, I mean, he was there at 2:30, and I get it, if he was not supposed to be there, but there was nothing nefarious about him being at the library reading a book. Granted, if he was told not to be there, and I've explained to him that, I don't see it, but if they're saying that he can't be at any part of the university, whether he's at a library reading a book as a part of, because his conditions of probation said he had to get some type of GED or whatever. But I'm asking the court to consider giving him a PR bond on this case, because outside of this, I don't see any other criminal history. I see that he's on a deferred. And outside of this, there is no other criminal history, and the deferred is for a state jail felony.
Yeah, I do see it. But I'm gonna be honest with you. It's a 228.
And if they do judge, then, that's an argument for,
That's
but
good.
based on these facts, I would ask the court to give him a PR.
I'm hesitant. I'll be honest with you. I'm very hesitant. You know, especially and not necessarily that I am targeting your client or anything like that, but there's been a big issue with people going to that university that don't belong there. Okay.
And Judge, I do agree, but he was in the library.
I understand.
And I get it, Judge, I do. Even if, I would think a PR bond would be appropriate in this circumstances due to the limited criminal history. He is on a deferred, and the trespass was at 2:32 p.m. at the library.
Do you see, all right, Miss Anthony, can you pull that again? What do you see anywhere on there what the date or time of offense?
Let me check, Judge. Yes, 2:32 p.m.
And it's at the library.
Yes, at the library.
And Judge, if it was 9:45 or 12 a.m. at the library, then I would.
No, I understand. Okay, from what I can tell on his burglary case, he never bonded out.
Right, there's no amount of bond.
So it looks like he got charged with burglary. And
And he sat there for
I don't know how long. I mean, I see that
5 months.
maybe, I do see that he was charged. Well, it was a 2B warrant. This was January of 2024, but it looks like he didn't get detained until December of 2024.
And it looks like he played out
And
the,
then he pled up in January, the
Right.
next month. So he spent at least a month in jail.
and the bond was only $1,000 on that case.
Let's see how much the bond was. Yep, you're right, it was 1,000. That particular case, the allegation, he entered University of Houston Stadium offices and allegedly took some items that he pawned later on. All right, he was given $1,000 bond, but they did not give him a PR bond for that case in state jail, the state jail felon. I'm very hesitant at giving him a PR bond. I really am. I'm sorry. I'm just super hesitant doing that.
And Judge, would you consider lowering that? I mean, even, I can tell you now any amount of bond, but at 2,500 on these circumstances, I think it's.
Yeah, I know that was the magistrate who did that. The magistrate gave him, excuse me, a $2,500 bond. All right, let's do this. I'm not giving him a PR bond. I'll split it in half, $1,250. And the 2,500.
So whether, trespass where he was advised, because they said.
Yeah, we don't have it yet, but we'll have to request.
Okay,
the
can you
warrant.
request?
I'll
Yeah,
put it in there.
thank you.
I mean, I'm sorry. I'm just very hesitant of giving you a request. I understand exactly what you're saying. He was at the library, allegedly he was reading, et cetera, et cetera. He just got out of jail in January. And for burglary of the same location, University of Houston, and then he was given a trespass warning.
And that's the
So-
thing that's in question, Judge, but she's gonna request it to be.
Okay,
She's got
so-
probation conditions.
So, I mean, if he was given trespass, he had to know you can't come back here, period. I know. All right, I lowered the bond to $1,250. Let him know that if he bonds out, he is not to go to anywhere near the University of Houston. Because I do see bond conditions that specifically say, don't go over to the University of Houston, anywhere on campus. It's a huge campus. So anywhere on campus. And then let's just get a date from Millie, whatever date you want, okay?
Okay. All right,
Okay,
thank you,
you're welcome. Yes, ma'am, come on up, how are you?
Hi, Judge.
Good morning. You haven't heard from Ms. Pybus, have you?
Judge, she let me know she's still in her bail review hearing.
Really? Is that in
Yes.
felony court?
She's in court 11. She's covering 5 courts today.
Can somebody else talk to the complaining witness? He's
Yes, let me
here.
ask her. Sounds like a fun hearing.
All right.
She did let me know she can give him a call, but I told her you wanted it in person.
Well, because she's here.
He's here.
Yeah, I mean, now that he's here, let's take advantage of it. I mean, if you or somebody else can do it, that's fine with me.
Yes, Judge, let me ask Chief.
Okay,
Oh,
Your Honor, I can speak
Okay.
with the.
this is on an assault case. It's just a rip call, okay? And it's going to be in reference to Martinez, Damaris Martinez. And the complaining witness is a Jonathan Martinez who's here in the courtroom. And it's just a rip call. So if you can handle that, Ms. Siegler, I appreciate it. Thank you. Yeah, I'm sorry. Yes, ma'am.
Mark Solis, Your Honor.
Solis?
This is kind of a weird one. I was just looking at the complaint on this one, Your Honor. I believe you've already found PC, but I was eyeballing.
It's a harassment. Let me see
It's a
here.
couple phone calls. Apparently, his sister got into a beef with a complainant, and so he made some kind of foreboding phone calls, and they interpreted it as, to me, a little outlandishly, that meant he was going to show up at their house and shoot them up, even though he said, I believe the quote from the complaint is, "You have something coming, and I have a surprise for you."
I think the to be warrant that was alleged to have occurred January 16th. I'm looking at the to be warrant. Baytown PD, dispatched to location on Main Street in Baytown. Spoke to Charlotte Reyes, complainant. Do you know the relationship, if any, between?
This is, my understanding is, Your Honor, the defendant was backing up his sister who had a tiff with the complainant.
Oh,
And so he is the brother, the big brother, who apparently is, yeah, that's where these phone calls came about, at least from my reading of the complaint. But this is kind of a weird, you get from, I have a surprise for you, you've got something coming, to he's going to show up at their house and shoot them. I mean, that feels a little.
Let me see. It says complainant, they received a call from a Charlotte Reyes. Stated that her daughter, Jasmine Reyes, got into a verbal fight with her friend Mia. Words were exchanged, but the girls decided to squash the dispute. Then she said that Mia's brother, who is your client, Mr. Solis, started making phone calls to Jasmine's phone while Jasmine and complainant were at home in Baytown, stating things like, I have a surprise for you and you have something coming. Well, I mean, that's.
But this is after the issue has been squashed, as they said, which is kind of.
I understand that. When someone calls you and says, you have something coming, and you just gotten into an altercation, and then you come to find out that the person that's contacting you is the brother of the person that you had an altercation, I can see where this individual would feel.
Just seems kind of vague is all I was trying to say.
Well, I know. Okay, let me read some more.
Sorry, it was 37 times 11. Thursdays, right? Yeah, that's 36.
All right, did you read the part where it says that the complainant called and spoke to her mom, your client's mom?
Mhm.
Then she could hear in the background yelling he was going to come and shoot her.
That sounds like extreme hearsay within hearsay within hearsay within. I don't know what that is, Your Honor.
I know, but this is just PC.
I know, it just seems a little.
I know.
An intriguing complaint.
I know, and she said she knew the defendant's voice from conversations she's had.
It's quite the family dynamic.
All right. Okay.
We're just requesting a bond on this one, Your Honor. It just is kind of a unique complaint.
Yeah, he doesn't have a bond. All right, he's got an active case of tampering with a witness.
It is a case that's been pending out of the 180th, Your Honor. It looks like, I'm not counsel on that, but
I
it's
know.
been pending for some time, for about a year now.
Posted a $35,000 bond on that case. So that leads me to believe he's got access to funds.
Although I am court appointed, Your Honor, so.
Because he's in custody.
Or maybe he depleted that 30, or all his money with that $35,000 bond.
Years old. I'm not giving him a PR bond. So I'm concerned, you know, tampering with a witness, is not a very, mild offense. Same thing, had contact with Baytown PD in reference to, I'm looking at the tampering. Okay,
Would it comfort the court at all to know that, standard bond conditions on the felony would be no access to a weapon? So for this to be proposed that he would have access to a gun to threaten the harass the complainant would be a violation of his bond conditions, and there's no BVR pending. So
well, I agree with you there, but
access to a weapon should not be a possibility in order to give the complainant foundation for their harassment concerns.
well, I mean, I don't know what in terms of a specific condition he's got on his probation. I haven't looked that far. This is not good. I mean, I hear what you're saying. You know, he's 18. He probably is not thinking of the words when he.
I don't disagree at all, Your Honor.
No.
I'm looking at the foundation of this, not the other case. I completely respect the concerns regarding that bond. But he is still on bond on that case, even with this going.
Well, he's on, you're right, he is on bond. Well, actually, he's on bond. And it's in the 180th. And he's running the big risk also of having that bond revoked.
Right. And
By
this
that
case is
judge.
kind of odd, to say the least. And if he is not violating his bond conditions, which speaks to the fact that he does have felony bond conditions and they have not BVR'd him, then he shouldn't have.
Well, not yet,
access to it.
because it just happened on Saturday.
Right, but I believe the date of the complaint was back in January.
No, you're right. And obviously he didn't get booked into the jail until the 11th. And usually whenever we have bond violations is whenever they get detained. That's when they usually do the bond violation reports. And he just got detained and booked in on the 11th.
What I meant, Your Honor, and I completely agree with what you're saying regarding his recent arrest, is if there had been any conclusion that he had access to weapons or was using guns or threatening or displaying any guns towards the complainant, then clearly they could have BVR'd him at that time back in January.
No, I agree with you there, but he didn't. All right. All right, I'm going to give him a bond. He made a $35,000 bond on his felony case. That's quite a bit. He paid a surety bond on that one. And that was tampering. And I looked at the PC on that one. It's also words. Same thing, just words. And whenever they gave him a bond, they gave him a $35,000 bond on words. Same thing, just words. Like on here, words. So I'm just really concerned about this. Miss Anthony,
Yes, Your Honor.
this case on Solis, do you know if anyone from the state has had any contact with the complaining witness?
Not yet, Judge.
Yes.
And this is on, all right, I'm gonna give a bond of $2,500, assuming he could make that. And we're also gonna issue bond conditions. He's physically here, right?
Yes, Your Honor.
Okay.
You just mirrored the felony bond conditions with your permission?
Let me see what the bond conditions are in felony. It'll be similar, but he's gonna have no contact with the complaining witness.
Yes, Your Honor.
Yeah, I do see no contact with that complaining witness, no possession of firearms. I'm gonna add a few more things. Just because of his age.
Yes, Your Honor.
So I'm gonna add no contact with the complaining witness, no firearms, and also because of age, no alcohol or controlled substances. Not that there
No
is,
speaking, so he doesn't get in trouble again.
sorry?
I said no speaking. Touche. Yeah.
I know. You know if he's in school or whatever?
I don't know that far, Your Honor. I have a 15-year-old, so I can definitely, thinking without speaking comes at this age. It doesn't help the case. It just
I know.
is what it is.
All right, so I'm gonna have him come out here in a few minutes so they can sign those bond conditions. I'll let Ms. Garcia know what they are. And then, if you want to just set his case, does he have a court date in his felony court?
It was pushed out until July, Judge, in order to, or maybe it wasn't July. It was right after the next court setting for the felony.
Okay. All right, no worries. So then, in a few minutes when Ms. Garcia is finished with this particular individual, we'll bring him out, have him sign the bail order. Not bail order, bond conditions, and just reset the case. Okay, you got it. You're welcome. Thank you.
Judge.
Sir, morning. How are you, Mr. Yocum?
Big Judge.
Yes, sir.
I've got Mr. Freeze. I believe, I spoke with Kelsey, a little bit about this today. We were trying to get, he's on page 6, Judge.
Thanks.
Trying to get a PTI. We've given her the mitigation, AMC. He has a little bit of criminal history, starting back in 2002. He had there was, here, I can tell you, they can tell you this is why it's complicating it. No, photo ID in 97, that was rejected. Deadly conduct in Hayes County, $10 fine in 01. Bail jumping out of Hayes County, that was rejected. Theft, misdemeanor theft, out of county dismissed. The biggest one is his PCS case from 03, 04. He did 10-year deferred on that. Has a DWI and then an old theft, which was a theft by check, that he pled no contest to. That was like a $20 check.
Okay.
Nothing
And it looks like he served 8 years TDC for the
on the
PCS.
Yeah, I think he got revoked on the probation. because-
On really? On the possession case?
Yes, it was
All
the
right.
manufacturer, deliver, and a PCS.
He said the ultimate plea was to a PCS, but anyway, that's neither here nor there. It's a felony conviction. There's a lot of little hiccups, but this is an AFM. We've done the AMC.
Okay.
Kelsey was making him 12-month deferred. I think I talked her into a 9-month deferred. The issue is he does apartment management, has been doing it since 05. They are not hiring him on the AFM or assaultive type offenses right now. So what I'm trying to do.
So he's employed right now? No, not yet. Okay, got it.
So I'm trying to get him back into his field.
Got it.
And so what I told Kelsey I would do is I'm gonna have him do the online DIPP class. Maybe I'll let Kelsey talk to him in the hallway. She talked to him. So I've got to bring her one more thing. I'm trying to get a PTI, even if it's supervised, because he at least can represent truthfully to the management. I'm on this PTI. It will be eventually dismissed.
If I successfully complete, yeah.
So I just need a little bit of latitude. Let him do the BIP online. It's not the 16-week in person. Just one reset will probably have enough.
But the BIP online is for how long? It's several.
Yeah, but you can do it at your own pace.
I know. Do you know what the BIP program online would be or entail in terms of how many sessions?
Collective. I'm sending it to a different, I don't know what they have.
Oh, I see. It's
I
different.
sent this to Kelsey, and so I said, look, when we have him do an online BIP, he can do it at his own pace, and it meets court requirements.
18, is that the online one too? Okay. And that one, does it say on there how long it's for?
I don't know what she's talking about, but I've got.
That's the one from the probation of the for.
Oh, okay, I've got, 12, 18, 24, 30, 36, 52.
Hours.
Range from $53 to $115. So I was gonna have to do the 24-hour.
Talk to the state. Now, if they're willing to accept that, that's fine with me. I don't have a problem with it, and I don't mind resetting it. But I just need to make sure that if that's acceptable, because we need to get it going, because it's pretty old. This case is,
I understand
600.
it's not going on trial docket.
Yeah.
The state has a decent case. I'm just trying to resolve it in a manner that.
No, I understand.
Work.
I
And
understand.
this is, I just want to be clear, this is outside of their purview. This is for her. This
Right.
is for her to have in her file.
Right.
So if you just give me a reset, I'll get the bit to her.
Okay.
And try to get it to conclusion
Okay.
by the next session.
All right, so you're here on Brady?
This is, the case with,
Oh, I remember this one. Yes, the harassment, yes.
the state and I have talked about it.
Okay,
They want, we are in agreement about a time served, he's got 37 days.
think
But,
we talked about
we
this
wanted to
earlier.
approach you and see what you said.
I remember we had a conversation about it.
Yeah.
And I remember how uncomfortable I was accepting the time served. And is this on one case and dismissing others or
No.
on all three? He's got,
But I mean, he's been in there for now 37 days.
all right, Nancy,
So what
this is on
that?
Brady, page 21. Can you tell me his credit? So what's the offer from the state? Because I believe if I remember correctly, last time I was saying 3 digits.
Yeah,
Yeah, 3-digit, right?
and it's still 111 at this point.
Yeah, you're right, 111 on 37 days credit.
He is going back to Mississippi, Your Honor.
Okay.
He's from there. And I don't think he's ever gonna come back here.
Yeah. This,
35, 36, and 37.
okay, so I can give him 37 on all 3 of them. So what's the state offering?
111 days. Well, we did the math on all of them, so
No, I
one,
know. 37, that would be 111.
yes, 111 and then 108 and 105.
I can give him credit for, did you say, what's the most, 37? I can give him credit for 37 on all 3 cases since he's been in custody. Yeah, since he's been in custody all this time. However, man, 111 days. I was thinking higher than that. I'll be honest with you.
Well, Your Honor, but you know, Your Honor, the maximum he would be in there would be 2 more weeks. And, you know, he's got no record whatsoever. I know these are scary things, but with this on his record, it's a permanent tattoo for him.
I hear you.
If he gets into this kind of behavior, he's not ever gonna have the benefit of the doubt. You got 3 of them that will stick.
I know. All right. I will accept 150.
You will accept what?
150
150.
on all 3 of them. He has to do 51 days.
51 days.
Okay.
Okay,
So that means he's got to do 2 more weeks
okay.
and then he's done.
Okay.
But on all 3 of them.
On all 3 of you, gonna write it up?
Now, if you want to do it today, that's fine.
Okay. I also have another client on the docket today.
Okay.
Ms. Bailey.
Oh, Bailey, yes.
Has a motion to withdraw, Your Honor.
Is she here?
We had some confusion about that. She is here.
Okay.
But I think that, she did discuss with me the bond issue. And, I do show that you have bond violations. However,
Yes.
Your Honor, I think that those were maybe.
Skip test. She was skipping her test.
She had switched devices or companies, and so they had to upload.
No, I know. It's nothing positive is skip test. I do have one positive blow on May 3rd. She tested positive on her blow on Saturday.
According to my client, Your Honor, I think it was a bad blow, but I think she immediately blowed thereafter.
I don't see that. I don't see if she blew
Do you
again.
have the report
Yeah,
itself?
I don't have the report, but I just have the incident .03.
Well, could we, yeah, right, and her, you know, the classic, you know, mouthwash issue, but she did re-blow.
I don't
So
see that
that
on
would,
here.
eliminate if.
Well, I don't see that here. I don't see that she blew again. Do you see that?
This is on who is your, who's it on your?
Oh, I'm sorry, Bailey. It's on Bailey on page 2. It's the BVR, the DWI.
Ask the case manager if she sees, like normally whenever they do retest, they include that in the DVR.
Yeah, I know. That's what I
But
saw.
I can double check with her.
All right.
She didn't
Now-
call and reported it.
I'll agree. It's a very low amount, .03. It is very low. Very low amount, .03.
Yeah,
All right. Do you still want to withdraw on this case?
I need to withdraw, Your Honor. We have a misunderstanding about, the case. She thought I was a court-appointed lawyer and I'm not.
Okay. Is she here?
She's here.
Let's bring her up. Miss Bailey? Now, I do see, that you filed a motion to withdraw on one of the cases, but not the other.
I'll file it.
On the MRP, you haven't filed it. And I'm assuming the MRP is a result of the new case. Let me see. Yep, it is. All right, ma'am. Is it Antoriana Bailey? Antoriana, Miss Bailey, you're here with your attorney, Miss Sims. I'm going to address the first part of why you're here. Your attorney, Ms. Sims, has filed a motion to withdraw off your case. She wants to get off your case, okay? And whatever issues you might have, I'm not going to force Ms. Sims to stay on if there's some issues between you and her. So I'm going to grant her request to get off this case. So if you would file your motion to withdraw on the MRP, I'll sign both of them. I do see that you did on one of them, but you didn't do on the other one.
I'll file that today.
So go ahead and file that and I'll grant your request and I'll allow you to withdraw from that case or both cases. Now, as far as I'm concerned with Ms. Bailey, you are excused, Ms. Sims. So go ahead and take care of your other case. And then I'll speak to Ms. Bailey about another attorney, okay? Thank you. Ms. Bailey, you no longer have an attorney, so there's two options regarding a lawyer. I can reschedule you to have an opportunity for you to hire another lawyer, or you want me to appoint you one? I will appoint you an attorney on two cases. Now, before I do that, there's one other thing that I need to address. Millie. Oh, I'm sorry. Whenever you finish, I'm ready. I do see that you are charged with driving while intoxicated. You're on probation for DWI. You picked up another driving while intoxicated. You are on bond conditions on your driving while intoxicated, in which you have to blow on an interlock device. Okay. And I see that when you blew on your interlock device this last time on May the 3rd, it tested positive for alcohol on your breath. Okay. Now, don't have to say anything, but are you aware that you have to blow again? Every time that your machine. I'm sorry, what was that?
I thought like if it's just a bill, it's just a finger, that's why I reached out to my.
Blow again. Now, here's the deal. That machine tests for your breath and it tests for alcohol, but it cannot distinguish alcohol from an alcoholic beverage or alcohol from something else like medicine. Okay. So it can't tell the difference. So we require you to blow 3 more times after the first time that indicates a positive test for alcohol. And the reason we do that is to make sure it's not something else. Now, what I see here is the amount that you blew is a small amount. That leads me to believe it's possibly not alcohol, but we don't know because you didn't blow again. If you would have blown again, and then the second or third time that you blew, if I noticed that it went down, we can probably say, nope, that wasn't alcohol. That was something else. Okay. So I need for you to understand, Ms. Bailey, every time you blow, if it indicates a beep, possible, you need to blow 3 more times after that. You have to wait 5 minutes each time. You blow, wait 5 minutes, blow again, wait 5 minutes, blow again. 3 times, remember, because otherwise we don't know. So I just wanted to bring that to your attention. Secondly, I see for a period of 1 month between April 4th to May 7th, there was 23 times that you did not blow on your machine. Okay, yes, ma'am.
Yes, Judge. I see that she called for trial stating that since she is on probation for the other case, that she thought she wasn't supposed to use the other device. And so she kept blowing on the one that she got under probation, and she thought that pretrial would have access to those files, but we don't. So the case manager told her, admonished her about having to use both devices in that case.
Did she have an interlock in a car and a probation?
Portable, yeah.
So she got portable on the probation, portable on this, but the same machine, right? It's the same one?
Like, at first I was in sober court, so like, with the device, I went back to Lifesaver, and when I got that device, they didn't add pre-trial, so I had to call for reporting.
I know.
And then-
You only have one device though, right?
Yeah. I only
Okay.
have one.
All right, so here's the problem. Unfortunately, you fell in one of those cracks that's kind of like, that we can't fix. You got probation conditions and you have bond conditions. They're separate. One doesn't have to do with the other. There's two separate things. Okay. So I understand that when you are on probation, they tell you one thing, but that's for that probation. So just to be on the safe side, if you blow and it takes positive, blow again. Don't worry about it. Just blow it again. Okay. And hopefully you'll be okay. Now we're gonna appoint you a lawyer on both cases. Okay. And then make sure, because I don't want to see another report. Is your machine working now? Okay, no, I'll just make sure it's working and you haven't had.
Lifesaver.
Okay. And have you had any problems blowing during the time periods that you're supposed to blow?
No,
Okay, because you have to blow 3 times a day.
they have it like for 4.
Or, okay, well, just make sure you blow every time during that period, okay?
Okay.
All right, any questions, Ms. Bailey? You don't need to see her, right, Ms.?
No, you're.
Okay, all right, just have a seat. I'll appoint your lawyer. Millie?
Yes, ma'am.
Page 1 and 2, Bailey, court appoint, 2 cases.
Thank you.
Okay, yes, sir, come on up.
Thanks, Judge.
How are you?
Well, that's the reason I'm here.
Because you're doing great, right?
Another case, another court. This case is on your docket tomorrow is a DWI. And it's and it's set just because there was a bond violation. As I understand,
I need a case number.
it's 253-9185. He blew unusually high below and then, as I understand it, he passed it a short time thereafter, so I checked with the lady here, said, look, I need to check with the case manager first.
I do see interlock. I do see that he had a high breath on the interlock on May the 2nd.
Exactly.
And then, let's see, May 2nd was a Friday, but I don't see that he blew again. Okay.
It is set, he has to be here. And it's set to be for tomorrow. I would ask, I need a week, yes, next week. I started yesterday, my heart is going like I was running a 100-yard dash.
Oh, okay.
And that's never happened before. I need to, of course, I've never been 78 before. So I've got to go deal with that.
No worries. All right, let's do this. Do you have contact with your client?
Yes, I can.
Can he be here next week?
He can be here next week.
And what day?
Here alone.
No, I know. I like for you to be present also.
Oh.
What day next week are you available?
I am.
What day next week?
I'm still among living.
Well, I hope so. What day are you available next week?
Midweek, you name it, Judge.
I mean, I'm gonna be here every day next week. Between Monday and Thursday,
And so you just got appointed to.
because we can't do Fridays.
Okay. Let's just,
That's
let's do,
it's the week of the 19th.
it's the week of the 19th.
Yes, sir, May 19th to the 22nd.
Let's do Wednesday.
21st, okay.
First,
So get with my coordinator,
okay?
give her the case number, and tell her to off docket it till May 21st.
I'll do it, Judge.
You got it.
Thank you very much.
Ms. Siegler, were you able to talk to that complaining witness?
Yes, sir.
Okay. Well, let's see, you want to continue the case because it's set on the docket for today. Do you need to get with the state with, is it Ms. Pybus to let her know?
Yes, sir, and I spoke with her, but she was still thinking about what offer.
All right, let's reset it. We'll reset it. Okay, thanks. Yes, ma'am, Ms. Frey, you need approach?
I do, Your Honor.
Yes, ma'am.
I got a good one this time.
Oh, okay.
A real one. Anthony is Harris, I just received him,
What's the last name?
Harris.
In custody?
Second last name, yes.
Apparently he was bond forfeited on the 9th for not being present, and he was actually in medical at the jail.
Oh, I see. Let me look at it.
So he's got a good excuse.
That is a good excuse.
I got mine.
Well, you went for one. That's not
See?
bad. That's not
It's a
bad.
better argument than my last one, but I'll take what I can get.
All right, so did he just get, did he get detained again for some reason? I guess he got arrested, rearrested again.
My understanding was just that there was that bond forfeiture from the 9th, Your Honor. Beyond that, you're already ahead of me.
Yeah, let me look at it real quick.
All right.
Oh, this is the only case he's got.
He seems eager. He said he just got out of state jail, so he's kind of eager to resolve.
All right, so he bond forfeited in 2022 though, right? That's what I see, 2022
On the same case?
on this case. Yeah,
He was been in state jail, Your Honor, in Paris, Texas. So that's the only thing I can think of is that he was still in custody back then. We just didn't have a hold on him. He's telling me he's been in custody for some time now. And then he just got out of state jail when he got picked up on this, probably an open warrant because they didn't put a hold on him in state jail for this case.
well, I see a 2021 conviction for possession of a controlled substance where he did 2 years.
That's probably what he's referring to.
But that would have been over with by the time that he got arrested on this charge. So he was free when he got arrested on this charge, March of 2022. So he was not at TDC. He might have been on parole, but he wasn't detained. And then he got released on this charge on March 15th of 2022. And he was requested to come to court March 22nd of 2022, which he did. Then we rescheduled this case so he can get a lawyer to May the 9th of 2022. And May the 9th is when he bond forfeited.
And it doesn't show what he was in custody for prior to,
Doesn't say,
okay.
doesn't say he was in custody. Then it looks like he got detained again in May. Looks like possibly May 9th.
Okay, so he was in custody on May 9th then, but for something else.
Yes, I'm
Okay.
assuming it's either this case or something else, but I don't know. Unless he had something else pending, but I don't see anything else pending. So probably what happened is somehow or another, he got the attention of law enforcement. They found the warrant and said, let's go. He took him in.
He has what he's reporting to me, Your Honor, is that he has a heart pump and he has the device on him, that he was in medical getting that installed on the 9th. So I'm not.
Oh, he was here on the 9th, but he bond forfeited in 2022.
Okay.
So, he
My
didn't
apologies.
show up.
I thought the law forfeiture was from the.
No, that was 2 years ago, actually 3 years ago that he bond forfeited. So he's been out free for 3 years until he got the attention of law enforcement and they
Gotcha.
put him back in. So I do see that he did go before the magistrate. He does have a bond. And don't know if he can make it, but he does have a bond.
Okay, let me go check in with him and see. I guess I'll speak with the state too and see if he had a hold during any of that time.
Okay. All right. And then just let me know.
Because he's been in and out.
Oh, I'll be around.
So will I, Judge.
Okay, thanks. Okay.
I will let me let you know, it's like he's been in and out.
And the Siegler. Also, I sent you an email about a non-disclosure.
Yes, sir, I'm unopposed.
Okay. James Hawthorne, are you here? You know, Mr. Hawthorne? Come on up. I tell you, I keep forgetting about you. I apologize. What's going on with your license?
Got a payment plan,
Okay,
and but they just sent me like 3 days ago, they just sent me and said I had 2 more owes.
oh God, really? Did they tell you how much?
I gotta figure out what that's about.
They didn't tell you what it was?
They told me because I had criminal and misdemeanor, they said it might be from another like a substation. I think like
Oh, God. Do you think it's tickets?
Yes, I know it's tickets.
It's just money.
Yes.
Oh, God, okay, so, all right, so do you want me to just give you another date?
Yes, sir.
All right, I don't mind giving you another date. I know, just, but do you think that you can pay them? You think you can pay all, because that's a lot.
I have to.
Okay, all right, tell you what, no worries, have a seat, we'll reset your case. Page 7, Hawthorne, he's supposed to say, let's reset him again. Let's give him at least a month or so. He's trying to get his license.
Okay.
Yes, ma'am. Oh, yeah. Let's see, thanks. Yes, ma'am, I'm sorry. Oh, yeah. The plot thickens. Yes, ma'am. Miss Anthony.
Judge, so on Mr. Harris, Antheus Harris, it does look like from 2022 to 2025, it seemed like he was in custody
Oh, yeah?
in Anahuac.
Oh, Anahuac.
He referred to it as Paris. I don't know what that area is, so I'm just
Chambers County, yes, I'm
Yeah.
not
Chambers County.
sure where that is.
Chambers County. You been to Chambers County?
only once, Judge. I never went back.
That's a long drive.
It is long.
It is a long drive.
146 and kept going until I couldn't, there's like a stop sign, 50 miles.
It's like I-10 east and you keep going and then you take the exit, whatever exit that is, and then you go south another 100 miles or something like that. I mean, it's a long ways. I know. I hear you.
But the good news is he couldn't show up.
All right, so let me look at it and then I can probably reinstate his bond. Let me see. All right, so Nancy, page 27, Harris, and this is Antheus Harris. Let's reinstate his bond.
Yay.
Now, I need to give him bond conditions though.
Oh,
No. Apparently there's a complaining witness.
they haven't been able to do the call yet, Judge.
But just I have to believe he doesn't know who they are, your client. I have to believe they don't.
Based on the case.
So just tell him no contact with the complaining witness.
Okay.
Oh, this happened at the rodeo?
Yes, it looks like the complainant might have been a security officer.
At the rodeo?
What happened at the rodeo stays at the rodeo, Judge.
Just no contact with the complaining witnesses
Just saying.
and no weapons. I know. So Ms. Garcia,
Yes, Your Honor.
Harris on page 27, Antheus Harris,
Yes,
no contact with the complaining witness and then no weapons.
Yes, Your Honor.
That's it.
Can't go to the rodeo.
Nah, I'm not gonna do that. Just tell him to behave. 44 years old, so.
Not everybody grows up at the same rate,
Oh,
Judge.
I hear you. All right, you got it. And then just tell Millie that he'll be released, or just say he'll be released and we'll reset him. Okay, you got it. Hey, that's a win. How about
One
that?
out of 3 is not bad, Judge.
No, not at all. Yes, sir. Morning.
Marisa Esparza.
Esparza, okay. Now I've spoken to Esparza already. Have you spoken to her?
Yes, I spoke.
Okay.
I was just wondering if the board would be open to hearing phone calls again, so I'd like.
Yeah, in fact, I think this was it was kind of iffy. I don't mind hearing probable cause. So Miss Anthony
Yes,
Esparza,
yes.
let me hear PC. Now, let me just preface this. I don't know if you saw the report or anything. Allegedly, she was going to be detained and arrested for PI.
She was escorted from the bar, she voluntarily left.
Well, but they were going to arrest her for PI. That's what I heard.
Didn't see any facts that were kind of articulating the fact how low she was, why that was necessary.
I mean, was this Pasadena PD? No,
It's
HPD.
HPD.
Okay, so let's hear PC on this one.
Yes, Judge, and I can read directly from the DIM.
Okay.
On Sunday, May 4th, 2025 at 1:38 a.m., officer was dispatched to a disturbance at a bar in Harris County, Texas. Officer arrived at the bar and located the defendant at a bar by the name of Hugh O'Connor. Manager pointed the defendant out to officer, identifying her. Officer instructed defendant that the owners of the bar needed her to leave the establishment. Officer escorted the defendant outside of the bar to further continue a public intoxication investigation. As officer was trying to gather the defendant's information, such as name, date of birth, driver's license, defendant refused multiple times to identify herself. Officer was conducting a public intoxication investigation to transport the defendant to the sobriety center. In order to book the defendant into the sobriety center, defendant must be identified with a name and date of birth. Officer tried multiple times to retrieve identifying information and was refused on every attempt.
Articulate that, the defendant's level of intoxication was the level of needing to arrest her and take her to the center.
Well, they weren't going to arrest her. I'm very familiar with that center. I don't know if you're familiar with that center at all. Okay, so here's what happens.
I understand things.
What's that?
You get taken there, you sober up.
Exactly. It's a center and it's located downtown. And what they usually do is they transport individuals that they believe are intoxicated so they could sober up. But it requires them to be detained. It's like they're arrested. They're handcuffed. They're physically handcuffed. They're placed in the backseat of a patrol car. They are, in essence, kind of like almost booked in, but not necessarily booked in. They check their records, et cetera, et cetera, et cetera. And then when they get to the intoxication center, they have to have all that information to be inputted. So all of that's inputted into the intoxication center. And then they have a place for males and females separated. And so the males go in one place, females go another place, and they have cots there. And they basically said, there's a cot, there's a blanket, there's a pillow, go, get sober. And then they check on them. And then when they believe that someone has sobered up, is good to go, they'll say, okay, you're released. And then they kind of do like a discharge. So all of that requires, yeah, exactly, identification and all of that, yes.
And kind of my feeling that, without any reason to actually arrest her.
Well, she wasn't going to be arrested, I know.
And that's what I'm saying, she didn't give her name, so does she necessarily have to give the name?
Yes, she does. Yes, because they have to, it's basically they have to book her into the intox. I know you've never been there. I've been there. It's kind of actually good. It keeps people from getting arrested and charged with. Yeah. And sometimes they'll arrest someone that they might think was driving while intoxicated, but can't really prove it. And so they send them over there too. So, I mean, I'll be honest with you, it's a really good program. Yeah. And if you go there on Friday or Saturday night, it's packed.
Yeah.
Unfortunately, I don't know if you've ever been there in San
I have not.
You ought to go. It's downtown. It's just very interesting. And I mean, it's air conditioned. It's a good thing, and so, yeah, so unfortunately, because she failed to provide that information, I want to continue with PC. Get with the state. I'm sure that we can work it out. They'll work it out easily. It's our first offense. Has never been arrested before. I'm sure that they'll probably give you some type of PTI or something. Okay. All right. Don't worry. You got it.
All right, so we need to do
Yes,
a
sir.
motion to this.
No, it's been established.
All right, so, enough, really, maybe.
All right. Yes, sir. Thank you. Yes, sir. Good morning. What you got, sir?
Mr. Fulton, FUL.
All right. Let me see here, Mr. Fulton. See what's happening with Mr. Fulton. Got a lot going on. Is he in custody? All right. Let me see here. Okay. All right. He's got 1, 2, 3 cases. Yep. Mischief, assault, terroristic threat,
Yes.
and a felony.
I think it's 4 pending felonies also.
Oh, God. He sure does. Boy.
So the cars came from all the cases.
All right, so it looks like he got arrested for a new charge of evading in the 232nd. Oh, God. Yeah. So he's on bond for assault, on bond for criminal mischief, and on bond for terroristic threat. And then his criminal mischief is fairly new because it was a 2B warrant. And, oh yeah, you're right. But he got the attention of law enforcement because of the evading. So he got charged with evading, and once he got charged for the evading, they found these 2B warrants.
Yep.
Oh, including another evading too. He had a 2B warrant for evading.
I'm saying a lot going on.
Oh my God. All right, let me see, check. The BVR that he's under is, let's see, it's I think it's the assault one.
Yeah.
I just need to check the date that he was given these bond conditions. Okay, he was given bond conditions February 7th. And so the other cases occurred after he was given bond conditions.
I hope so.
All right, well, unfortunately, I'm gonna have to revoke Mr. Fulton's bond on the assault. And then just reset his other cases, because he's got two $5,000 bonds on the mischief and terroristic threat, and he doesn't have any bonds on his felony yet because he hasn't gone to court. All right, just pick all three of them, or reset all three. I'm gonna revoke his assault bond, assault bond. And then I'm assuming he won't be able to bond out. All right.
Just do what we can.
I know, just reset them. You're good to go. Thank you, you're welcome.